Hi again, Attorney Steve Vondran. Welcome back. Happy New Year. We are back with our litigation whiteboard by popular demand. We had a lot of requests for people wanting to see more litigation whiteboard. So 2018, I got a lot of stuff in store for you. So make sure you're subscribing to our channel. We're now up over 5,000 subscribers. Thank you all so much for your support. It's been a great 2017, and we are here making the law more understandable and more accessible. Okay? So let's head to the Attorney Steve litigation whiteboard. Okay, so usually you're used to my big whiteboard, but we are doing a modified version of this today. So we are talking in this video about how to file a motion like a pro, filing a motion like a pro. Now, in court, when you're in civil litigation, motion work is a lot of what you do. It's not everything, but you end up filing a lot of motions. Well, what is a motion? Essentially, a motion is asking the court to do something. You say, well, for example, you try to get discovery from say you're a plaintiff in a copyright lawsuit, and you're trying to get discovery out of the other party, the defendant, and they won't give it to you. And you've asked them for the documents and the questions, and they won't give it to you. Well, you may have to then go file a motion with the court, asking the court to tell them to give you those documents. And so something like that is where you would file a motion, and you tell the other attorney, I'm going to be filing a motion on this. So let's walk through what I think are the 7 key pieces of filing a motion like a pro, okay? So let's go over here. First, as I show up here, this says meet and confer. Now, especially in federal court, you want to definitely be making sure you're taking care of your meet and confer obligation. And the meet and confer is essentially meeting with the other attorney or calling them by phone and saying, look, this is our position. Sometimes you're going to be citing them to case law. We think we're going to get those documents. You better give them to us. If not, we're going to file a motion. And the other attorney may agree. They may say, okay, fine, we'll give in. Or they may say, take it to the judge. I don't agree with you. I don't think the judge is going to do that. So that's when you do your meet and confer. And sometimes you want to, I would say usually you want to document that with an email to the other attorney. Since you failed to turn over the documents, we're going to be filing a motion seeking sanctions against you and your client. Okay, something like that if it's appropriate. Okay, so meet and confer is usually the first step of the law and motion process. Okay, so meet and confer. Next, you're going to want to make sure you check your court dates. You want to make sure you get a court date. Now, some of the cases, and I litigate in California predominantly, but some of the cases, the courts are clogged, they're full, and you may be several months out to try to get a motion date. So it's really important to know what you can and can't get. So find out what the nearest court date is. Realize you need to give, I would just say 35 days. You want to give a sufficient amount of notice to the other party. You can't file a motion. You can't file a motion and give them, 10 days to respond prior to the court date. You have to give them a certain amount of time in there. I think a good general rule of thumb is 35 days, but check your rules, could differ in your courts and whatnot. So get your court date. Step number 2, get your court date. Step 3, you file the motion. Now, your motion is essentially, it's a pleading. It's on your pleading paper, and it's going to be telling the judge, here's what's going on. I need this. I asked for that. We met and conferred. They won't supply it. We believe we're entitled to the documents. For example, that's just one of the motions. There's other kinds of motions. Sometimes parties want to extend trial dates, and if you don't, they're going to say, I'm going in ex parte on a motion. And ex parte on a motion just means there's an emergency and you're trying to get in there quicker and have the judge hear the case quicker. So your motion is going to consist of your legal arguments. It's going to, I put some things down here that might help you out. RJN, that's request for judicial notice. You may want to be making a request, and we'll go over that in another video, which I will be producing on that. That's a very popular topic. But a judicial notice is essentially things that are so undisputable that the judge would consider it to be evidence in the case, and the judge would consider your request for judicial notice in ruling on this motion. Okay, declarations is another one. You may have a declaration under penalty of perjury, and that's where you're telling the judge, somebody is swearing. Could be your client, could be a witness, could be an expert, it could be an attorney declaration, something where you're telling the judge under penalty of perjury that something happened or these are some relevant documents or whatnot, so the judge can consider that, excuse me, in ruling on the motion. So you want to have your motion, you want to have, excuse me, any request for judicial notice, any declarations. I put here points and authorities. These are your legal citations telling the judge why you're entitled to get what you're asking for. So you're finding the case law. For example, if you're in California state court, you want to be citing to California state court cases. If you're in California federal court, oftentimes it's good to cite to federal court cases, but also state court cases. So you want to know, whoops, you want to know what you're citing to. And you want to ask for relief. Make sure it's clear to the judge what you're looking for. The judge needs to know what you're seeking for relief, okay? So this is your documents that might accompany your motion. You can put a proposed order in there, which is what usually you want to do. A proposed order that the judge could sign saying, having heard the oral arguments of the parties, the court hereby orders defendant to turn over the documents. So you may want to prepare a proposed order. Now, always make sure you're checking with your court rules. If your judge has any particular rules, make sure you're checking on that. Check your local rules. And for example, in California, you also want to check your California rules of court. So there can be a lot of different things you got to look into when you're in litigation. Sometimes if you're in pro per, the judge could give you some leeway, but sometimes they don't. So you want to make sure that you're doing the best job possible. Now, so bear in mind, this is not legal advice. This is general legal information only. I should have said that at the outset, just so you know these are general. So don't rely on this until you do check all your rules, okay? So that's step 3 is the motion with the accompanying documents. Now, step 4 is what I have here, the opposition. And these are documents, by the way. That's why they're like that. But so the other party, the defendant, let's say, you're going to file and serve your motion on the defendant. Could be a motion for summary judgment, for example. So you're serving that on your opposition, giving them sufficient amount of time to respond. So they're going to respond likewise. They're going to be probably saying everything you're saying is wrong, that they may have their own request for judicial notice, their own declarations. They're going to have their own points and authorities that are contradicting yours, or maybe distinguishing your cases, but they're going to be opposing your motion. So that's the next step in the law in motion. Now, after that, the plaintiff, the party, the moving party, the one that filed the motion, is going to file a reply. Bear in mind also that there's page limits on these. You can't just write 500 pages. You're going to put the judge and the clerks to sleep. So, you may have page limits of 15 pages. You may get more pages for summary judgment motions, being that could be dispositive of the case. And now you also may have, if you're over 10 pages, for example, in California courts, you may need to put a table of contents and a table of authorities. So one is a table of contents about what your motion is about. The other is a table of authorities, which lists all the cases that you're citing to in your points and authorities. Okay, so that's really key to make sure, because you don't want to upset the judge. If you have these local rules you need to follow, or rules of court, make sure you're not exceeding the page limits. Okay, so you got to look all this stuff up. That's why litigation can be a lot of work. So then the plaintiff is going to get the reply. The moving party gets to reply to the opposition. In California, this is really a short one. You're talking about 5 pages or less. You can usually file extra motions if you want to seek extra page limit extensions. If that's critical to your case, you have so much you need to say, you need more pages to say it, then you file a motion for that. If you can't get the other party, once again, to stipulate or agree to it, which they probably won't. From there, usually the next step you're going to see is the tentative ruling. This is not in all courts, but this is in a lot of courts where they may issue a tentative ruling on their website. So you go to the website before the hearing. Could be a day before, could be 2 days before. Sometimes it's the day of. And you want to get that tentative ruling and read it and see how the judge is going to rule. And then in some courts, you can submit on the tentative and avoid the hearing. In other courts, they're just going to set it for a hearing and you can come in and make your arguments. At this point, you're arguing essentially your points and authorities, your evidence, you're arguing all these things, and the judge is going to make a decision and issue some sort of order or make a final decision on the case. So those are your 7 steps, the hearing being the last one. That's where you show up in court. Sometimes you can get court call, where you can appear by phone on certain motions in certain courts. Check on that. And this is a lot harder in federal court. A lot of times personal appearances are required. So that's a general overview of how it's going to go. That is filing motions like a pro. That's how we do it in the business. Again, this is general information. This is not exclusive. There's a lot of other things that can pop up during this process, but that gives you a good general overview. When you hear an attorney say, oh, well, you know, I'm in law in motion, or I'm on the law in motion calendar, this is the stuff they're talking about, okay? So I hope that's helped. If you need help with civil litigation, you can find us here on the web at attorneysteve.com. If you like this video, if it helped out, hit that like button. That helps us, helps keep us going here. And to really join the party here, hit that subscribe button, become a subscriber to get our latest free legal updates. As we like to say, be smarter than your friends. Okay, Attorney Steve Vondran out. Happy New Year. Have a great year. And we look forward to talking with you again. Take care now.